Good afternoon, everyone. I am CS Pradeep Chandra Joshi, working as Executive Academics in the Institute. It is my pleasure to welcome you all in the 27th session of Triple E Master Knowledge Series, which is focused on ICSI governance and compliance standard on PoSH. The ICSI, in its commitment to promoting good governance, has come up with the governance and compliance standard on the prevention, prohibition, and redressal of sexual harassment at workplace. This standards aims to facilitate the effective implementation of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 PoSH Act across all workplaces by integrating, harmonizing, and standardizing the diverse practices followed by the organizations. It provides comprehensive and standardized procedure for conducting meetings of the internal committee, ensuring consistency and efficiency. It also clarifies and streamlines the provisions related to complaint and inquiry mechanisms, offering greater coherence and transparency. By reinforcing the legal framework, this standard aims to contribute to a safer, more inclusive work environment for everyone. To delve deeper into various aspects of ICSI governance and compliance standard on PoSH, today's session is scheduled, and for detailed deliberations, we have with us CS Kavita Bhavsar, Company Secretary, Barmer Lorry and Company Limited, and two practicing company secretaries, CS Kavita Sethi Jain and CS Divija Dev. It is an honor to be given the opportunity to introduce them before all you learned people. At first, I just want to introduce our first panelist, CS Kavita Sethi Jain. She is seasoned professional with over 26 years of experience in legal and secretarial functions, compliance management, and corporate litigation. A fellow member of ICSI and qualified company secretary, ICSI UK. She is passionate about workplace inclusivity and has conducted over 125 PoSH sessions. She serves as an external member of PoSH internal committees for various companies. Currently, she also acts as Women Independent Non-Executive Director at Enki Wheels Limited. The second panelist is CS Divija Dave. She is a practicing company secretary and MBA, a passionate professional having expertise of working in the areas of corporate secretarial, prevention of sexual harassment in workplace, and CSR and ethics. She has been an integral part of the esteemed PoSH task force created by the Institute of Company Secretaries of India. Our third panelist, CS Kavita Bhavsar. She is a qualified company secretary with graduation in commerce and law, with over 2 decades of experience in handling secretarial, legal, corporate affairs. In a span of 34 years of working, she has worked with different types of industries. Currently, she is working as a company secretary of Barman and Lorry Company Limited and also act as first appellate authority under the Right to Information Act 2020 to 2005 and presiding officer of the Internal Committee of Western Region of Barman and Lorry Company. To welcome our esteemed guest and to give an insight upon the thought behind the development of the ICSI governance and compliance standard on PoSH, we have with us CS Ranjit Pandey, former president ICSI and the chairman of ICSI task force on PoSH. Presently, he is connected with the ICSI as the chairman of the ESG and Sustainability Board of the ICSI and advisory committee of the professional member of ICSI Institute of Insolvency Professionals. Please, Pandit Ranjit sir.
Good afternoon, everyone. I, on behalf of ICSI and on the behalf of, Board for Governance and Compliance Standard, welcome you all to this webinar, Triple E series, which has been started long back. I think this is also have the history of 7 years now. So today we are going to deliberate on governance and compliance standard on prevention of sexual harassment at workplace. Friends, experts are here, and in fact, two of the task force, three of the task force members are here, Divija, Kavita, in fact, Kavita Esquire. So they are there, and they are expert. In fact, I must say that contribution of all the ladies and in fact, all the entire task force was immense, and there was a lot of deliberation, discussion, dispute, and difference of opinion among the task force member and the member also. And we are able to frame this standard. In fact, at first point, there was a question that whether we should have that particular standard or not. But task force board has given, the council has given the task to the board. Then board has given this task to the say task force, and one small task force has been constituted, and that task force was having the say seasoned professional and practitioners like Kavita Divija and Mr. Manoj Kapoor, G.R. Bhatia. So all these members were there, and they have contributed immensely for development of this governance and compliance standard and standard on PoSH. So idea was to standardize the different and diverse practices prevailing in the various corporate arena, and different corporates were following different practices, though they are all compliant and trying to comply the law, but at the same time process and practices are different. Way to conduct the meetings were different, way to hold the inquiry were different, way to do the recording was different. So in order to standardize the whole practices and entire set of processes, we thought and decided that we should have the principle based say governance standard, which we should recommend to the corporate to follow. And that is why, with the objective to facilitate effective implementation of the PoSH, that is the prime objective and focus of the task force and board, was to facilitate effective implementation of the PoSH law. And second major point was that apply it to the all work places. It is not like that it should be limited to the say offices and premises. Apply it to the all workplaces, public, private sector, irrespective of the size of the organization, nature of business, or area of operation. So this is what and it is written in the scope also, that what is the scope of this particular standard. And third major point was that standards should be inclusive. And one of the major point of debate was that PoSH law is applicable and it is defining the say aggrieved women. So whether we should go for the general neutral PoSH or we should go for the say only aggrieved women, and we should follow the PoSH law itself. Then after a lot of deliberation, discussion, and a lot of heated arguments, I would say, it has been decided finally that let it be gender neutral, because say harassment can be of the female as well as male, and we should not even 1% cases should not remain unattended. So that was the objective, that was the logic, and we tried to make it gender neutral. So that is why standards are inclusive, ensuring equal, say, protection and support to everyone regardless of the gender, and that brings a definition of aggrieved person in place of aggrieved women. An aggrieved person definition it start with includes aggrieved women. So it is including everything. So these are the three major objectives of this particular PoSH standard. We have tried to collate the various things defined here and there. Something is defined in some other laws, something is defined in the PoSH law itself, and try to have a clear-cut definition or exhaustive definition of certain things like aggrieved person, domestic workers, employer, employee, internal committee, presiding officer, sexual harassment, and workplace. So all those things have been comprehensively defined in this particular standard. If I talk about the standard in per se, it has been divided into two parts. First part is, of course, scope, objective, and talking about the standard set processes and all. Second part is talking about second part is giving some specimen and formats, which is companies can easily use. So in the standard, we have divided the standard in two parts, and in first part, it has been divided into 5 parts majorly. First part is dealing with the internal committee. An internal committee, name anything, constitution, composition, qualification of the member, and in fact, qualification, we have tried to include practicing company secretary as an internal committee member. So that part has been specifically prescribed. Tenure, performance evaluation, fees and allowances to be paid. Meetings are completely not as per the secretarial standard. We have let it loose a bit. We have say some kind of understanding that this cannot be sacrosanct, say board meetings or committee meetings, because there may be a possibility that organization may not be company itself. So how can we say ask those companies to have the proper meeting, proper notice, proper agenda, proper minutes and all? So we have tried to make it more and more flexible, but at the same time try to maintain the uniformity, try to maintain the standards of say proceedings and recording. So that is first part is internal committee. Second part is compliance, a complaint and inquiry mechanism. What will be constituting as a complaint, how to file the complaint, and how to conduct the inquiry, and how it should be made more. And focus was always on the maintaining the transparency at the same time having the secrecy of that particular individual, who should not be exposed and who should not be unnecessarily targeted because of the complaint. So both the balancing has been done, that complaint process should be streamlined and inquiry mechanism should be such that fairness, transparency should be there, and at the same time confidentiality should be maintained. Then third part is PoSH policy. We are talking about what kind of PoSH policy should be there, how it should be framed, how it should be implemented, how it should be approved and all. Then fourth part is, and I would say that is most important and significant part, that is training and sensitization. If you are able to sensitize the people in the organization and working places, then I think 50% of the job will be done, and we will be able to take care this particular implementation of this law. So sensitization, and at the same time training the officials, training the people, training the say all concerned stakeholder for this particular purpose. And last part in this part one is annual report disclosure. What disclosure has to be made in the annual report of the company, or whatever report is being published by the organization, whosoever is the employer. So that part has been taken care in the fifth part. And then lastly, as I have told you in the beginning, that general neutrality we wanted to ensure. So after they say objective, then definitions and standards, we have included a separate paragraph called general equality and gender neutrality. On that particular count, wherever it is possible, we have tried to cover and apply the law or standards on the both the genders, or all the genders rather. Second part is to having the two specimen. One is policy on the prevention, prohibition and redressal of the sexual harassment at workplace. So a standard policy has been given in the standard, and you can always have that particular policy as a referral for framing your policy. And if you have already framed that policy, your policy in your organization, you can always refer it and improve your policy, whatever is applicable, get it approved in your board meeting. And lastly, we have provided the specimen brochure on the PoSH for displaying at the workplace. So this is what we have done, and this is the book which has been say released, and forward has been written in this book by none other than Dr. Rajiv Mani, IAS officer, Secretary, Department of Legal Affairs, Ministry of Law, Justice, Government of India. So this is the book. You can refer this book and standard. It will be very helpful in the times to come for all the say company secretary and all those who are practicing this PoSH law and made it as a career. So thank you very much. This is what I wanted to speak about this particular standard. Experts are there and they will dwell upon the various standards and what nitty-gritties are there. So that will be there. I'm thankful to President ICSI for organizing this webinar, and special thanks to the then President Mr. Manish Gupta for constituting this board and making this governance and compliance standard on PoSH a reality. Thank you so much. Now over to you and all the panelists. Thank you.
Thank you so much. Thank you so much, sir, for this detailed and deliberated introduction. Processing further, it is our proud privilege to have the three eminent speakers for today's session and get benefited from their words of wisdom in the arena of PoSH, and with their brief profile, we welcome them. We welcome them at the 27th session of EEE Master Knowledge Series and hope to have enthusiastic learning. All participants are requested to raise their questions and the queries. Then same will be taken at the end of the session. I would like CS Kavita Jain ma'am to start the presentation. Over to you, ma'am.
Thank you. Thank you very much. Good afternoon, everyone. And thank you for having me here. It's truly a privilege to share this virtual space with the subject experts. Surely we have very limited time, so let's dive right into the topic. Over the next 20 minutes, I'll focus on the governance and compliance standard relating to training and sensitization and gender neutrality. Okay, so I have made a small presentation for the purpose of making the subject matter more clear. Okay, just let me share it. Is it visible?
Yes, ma'am, it is visible.
So before we begin, let me share something with you, and then we will deliberate further.
Pradeep has a crush on Nancy and wants to have relationship with her. At an office party, everybody was drinking, dancing and enjoying. His colleagues know of his infatuation with her and provoke him to drunkenness and peer pressure. He acts physically toward her, which was caught on camera by partygoers who were filming the entire event. The next day, he apologizes to her, explaining that he had no intention of hurting her and that it was just the party mood. However, she is upset and files a complaint of sexual harassment.
So whether it is a possible case of PoSH, yeah, different mind, different opinions. Some may say yes, and others may say no. Also, very important question here is that seeking suo motu apology can be a valid excuse under the PoSH, especially in the scenario where the person didn't intended the behavior, right? There could be multiple questions on this particular scenario, and to navigate them, training on this subject is a must. So the law is women-centric, we all know, right? But we talk about gender neutrality. So when we talk about gender neutrality, including the PoSH Act, why the training is very important, let's deliberate on that. For any subject for that matter, the training is extremely important. And when it comes to PoSH, it becomes more important, right? Because training makes the people aware about what this law talks about. What has been constituted as sexual harassment, what has been constituted as workplace. These are the area which can be explained through training. It also ensures that the compliances are complied with under the law within the organization. And very, very important and the critical area is by having the right kind of training, it ensures the prevention of sexual harassment incidents at workplace. Okay. And here's the thing, if you look at the law places the responsibility squarely on the employers to conduct these trainings. But the law doesn't say that when and how this training should be conducted. And here, the standards come in the picture. Okay. If you look at the governance standard, they clearly talk about when the training should be conducted. The governance standards say the first training must happen within 3 months of onboarding a new employee. Okay. Whether only one training is sufficient? Do you think so? No. I always say that training is like servicing your car. You don't just do it once and forget about it. No, you need regular tune-ups to keep it running smoothly. And therefore, the governance standards say that refresher training has to be done annually. And they also define the timeline that annual refresher training should be done in the first quarter of the calendar year. So we have talked about that when the training should be conducted. And the training should not be actually a kind of a tick box compliance when it comes to PoSH. So what are the important ingredients for conducting the effective training is something which really we all should know. So when we talk about the components or the ingredients of effective training, for me, the objective becomes a very, very important question. The intent matters, the objective of PoSH training should not be provoking women employees to go and lodge the complaints. The intent has to be very, very clear that it should prevent the sexual harassment cases at the workplace. Okay, the right set and the right tone has to be made clear when we start talking about the training of PoSH sessions. And that has to be included when we talk about the training sessions in the organization. The second important aspect is key definitions and legal compliances. When we look at PoSH, the law is very crisp, However, it has a wide range of coverage. So when we talk about, say, workplace, because the PoSH law is for the prevention of sexual harassment of women at workplace. So we have to be very clear that it talks about prevention of sexual harassment at workplace, not at the roadside areas. Okay. So what constitutes workplace? Places from where you are performing your duties, fair enough. But places maybe like if you're working from a cafeteria or you are working from an airport lounge, can they be covered in the definition of PoSH? These are the things are required to be covered in the training session. Second very important aspect is sexual harassment. So my experience in this field says that many of us have an understanding sexual harassment means great amount of physical abuse or the molestation or kind of stuff. But when we talk about PoSH Act, it covers a range of behaviors which are considered as sexual harassment, particularly at workplace contexts. So whether singing a song can be termed as sexual harassment if somebody has unwelcomed it, or throwing a sexually colored joke, or passing an email with some sexual undertone, or leaning to a person, or asking out to a person, or proposing a female employees, whether these kind of areas can be considered sexual harassment under the PoSH is something which are required to be covered in the training. Third and very, very important, which Mr. Pandey also said that when we talk about women employees, and at the same time we talk about the gender neutrality. Okay, so who is women under the law? Whether the employees working within the organization are considered women employees, or it could be third person. So what is the difference between an aggrieved woman and a complainant under the PoSH Act? So I can give a lot of examples, but we don't have that much time available. The point I'm trying to make is that when we conduct the sessions or the training, these are the areas to be clarified explicitly with a lot of examples in the training session. So the stakeholders are aware that, okay, this is what constitute workplace. Even if I'm working from home, which is the new norms after COVID, that place, if something happens virtually with me, that can also be considered workplace under this law. Third and very important coverage should be is the reporting mechanism. So, under the law, the set of timelines have been defined. So the stakeholders should know that if something has happened with me, to whom I should go, where do I register my complaint, what is the timeline within which I'm supposed to file the complaint, whether there is a specific format under which the complaint has to be registered. So these are the areas which are required to be covered. We all know that it's not a kind of a Me Too movement, that 10 years after the incident or 7 years after the incident, one can go and lodge the complaint under the PoSH. There is a specific timeline defined that within 3 months of the incident, the complaint has to be lodged. Of course, certain exceptions are there. Very, very important thing, because we talk about prevention when we talk about training, right? So there has to be a checklist inbuilt, talking about certain behaviors, do's and don'ts. That okay, these are the range of behaviors which are acceptable at the workplace, and these are the set of behaviors which are not acceptable. So these kind of checklists to be provided or to be discussed when the training sessions are conducted. Very important. PoSH is a law, right? And it's a dry subject. So unless we make it interactive, it becomes very monotonous. So when we conduct sessions, I throw a lot of questions to the audience. I create, case studies. I create mock scenarios, and we deliberate on that, and it gives a lot of clarity, and it makes a lot of things interesting from the audience perspective. And at the end of the session, of course, there should be quick knowledge check. Very, very important. We have to see whether people have actually understood the law in the right context. So maybe somebody can just throw a question saying that, okay, whether proposing a female employee is considered sexual harassment under the law. And, let us hear what the audience is saying. So these are the broader coverage which one should have while conducting the sessions under the PoSH Act. And precisely those areas have been covered under the governance standard. So one, we talk about the awareness stations for the employees, right? And the second is the very, very critical body under the law is the internal committee. Earlier it was known as the internal complaint committee, but now it is known as internal committee. In 2016, the amendment was brought in by the government, and the powers and the duties have been enhanced in a way. Earlier, the responsibility of the committee was once the complaint comes, you are supposed to investigate into. However, in 2016, the nomenclature has been changed and it has been made as IC, meaning thereby this IC has two dual responsibility. One is to ensure that there is a mechanism in place by which you can prevent sexual harassment. Very, very, very critical. And second, if the case comes up, how the committee should investigate into the matter. Now, when we talk about it, the first role means when we, how the committee should play an important role for preventing the sexual harassment cases. So it's the IC's responsibility, it's the presiding officer's responsibility to, talk to the management, ensure the regular sessions are conducted at certain intervals. A check is there in the company, whether there is some nuances, some nuisances there, and how it can be handled before they turn into the sexual harassment complaint. Second thing is the IC training. Unless the IC itself is very, very competent, IC won't be able to handle the matters. So if you don't know ABCD, you won't be able to read XYZ. Okay. So the basics are very important. So when we conduct the IC training, it's very, very deep and very lengthy training. And the governance standard also says that when you have the IC training, what are the coverage which you should bear in mind while conducting the IC training? It says that you must talk about the basic concept, the foundation of the law, that why this law was brought in, what was the Vishaka guidelines, why in 2013 this act was notified by the government. Then what constitutes what constitutes sexual harassment, workplace, woman, bystander. These all things are required to be explained in detail to the IC members. Second, very important is to tell them that what are their roles and responsibilities. But the first is they have to work on the prevention, and second, if any case comes up, then what is their roles and responsibility? How should they handle the matter? What is the timeline given under the law? That within 7 days, you are supposed to send a notice to the respondent. Okay, within 90 days, you are supposed to complete the full inquiry. Within 10 days, you're supposed to give the report to the employer. So these are the things, confidentiality, principles of natural justice. A lot of these aspects are required to be explained while conducting the training of internal complaint committee. We all know that it's not a criminal law. It's a quasi-judicial body. Okay, and therefore the IC cannot act like a criminal court. Okay, IC can't say that portray once again that how the things have happened with you. Okay, so here there are two aspects which are really important for the purpose of IC perspective. One is the technical knowledge, and second is the human aspect, the psychological aspect. So the IC has to act in a way that IC can, gather a lot of information, fact-finding kind of a body, the role the IC plays. So IC has to be very, very empathetic. Of course, you should have the technical knowledge, but at the same time, you really have to act in a way when the person feels comfortable in sharing the details with you, be it the aggrieved person or the respondent or the witnesses for that matter. So the IC should know that, okay, law says the confidentiality is a must. Law says that, the documentations are required. Law says the examination, cross-examination, these are the proceedings which are required to be complied with while inquiring into the matter. However, at the same time, it is important for the IC to make the people comfortable, the concerned stakeholder comfortable that they can share their side of story, and therefore the IC would be able to take the right call or the right decision. Last but not the least is the investigation techniques. It's a really something where there is no defined set of rules. Okay, but when we talk about the investigation techniques, we all know that sexual harassment cases happens in the closed doors. There is no witness at times. There is no proof available. How would you investigate if somebody says that, okay, he has said a wrong statement to me, and the person said that, no, I didn't say that? How the IC will investigate into? So there are tools and techniques available by which IC can decide that, okay, these are the behavioral aspect, the body gesture, how the person is speaking. There could be circumstantial evidences, the back check of the person. These are the areas which are required to be covered while conducting the IC training. And these are the topics which have already been covered in the compliance standard. So this is the timeline which have been given under the law, and these are specifically to be told to the IC that within this time frame, the IC has to do its job if the sexual harassment complaints comes up or the lodge with them. So we have talked about two areas. One is the sensitizing the employees of the company on the PoSH law with the clear objective that the sexual harassment cases should be prevented. And second is the competence building of the IC if some matters comes up, how they should inquire into the matter so as to avoid further litigations. Third and very, very important thing is gender neutrality. We all know that PoSH Act is basically women-centric act, right? So how can it be made gender neutral? But we live in the current scenario where we always talk about equality. And therefore, the organizations normally do that they have the policy which talks about gender neutral policy. How can we go beyond the law? Okay, this is something which have to be articulated appropriately in the policy. So when we say gender neutral, it can only be implemented by having a written document and by ensuring that people, all the stakeholders, they are aware of. Okay, so in preamble, it can be written that, okay, the PoSH Act is gender neutral. However, the PoSH Act is women-centric. However, the policy is gender neutral. So whatever privileges, rights have been extended under the PoSH Act to the women employees, the same privileges and the rights are extended to the other genders also through this policy. By making this kind of statements, we are clarifying that, okay, we are complying with the PoSH Act. At the same time, we are giving the benefit to all the genders. And in terms of the language, we really need to be clear that, okay, in place of using the specific gender specific words like he, she, use the word they, them. Wherever we are talking about aggrieved woman, use the word aggrieved person, and kind of stuff we have to include in the policy. So in totality, if we talk about, we have to have a policy which is gender neutral, but when we draft it, we have to bear in mind that we are not ignoring the PoSH Act. Okay, so the nomenclatures and the coverage, the language, everything is important. And the same thing can be communicated while conducting the sessions, gender sensitization sessions, or, the trainings on PoSH Act to all the employees, to all the stakeholders in the organization. Since the time is getting over, I would just like to conclude it here saying thank you very much. For me, the PoSH Act and the governance standard, they both work together, parallel. The Act gives you that these are the things you are supposed to comply with, and the standards tell you this is the modus operandi through which you can comply them. With that, thank you very much. Over to you.
Thank you so much, ma'am, for the insightful and crisp and informative presentation. Now, the next panelist we have, CS Divija Dave. She will be taking the next session for the webinar. Over to you, ma'am.
Thank you. Good afternoon, everybody. Hi, Kavita madam. Thank you, Ranjit sir. Extremely honored to be a part of this webinar because PoSH governance and standards is something that we were extremely, looking forward to, because PoSH Act legislation is already there in place. However, as rightly said by the panelists here, that the modus operandi or the procedure of following certain things still remains vague. So with the help of these governance standards on PoSH, we have tried to identify how procedures can be made uniformly for all the organizations so that it becomes easy for compliance perspective. And since we have given this entire standards the name of governance, so we are now indicating a move from PoSH compliance to PoSH governance, because it's now time when we try to implement all of this in spirit of law. I'm going to specifically focus today on two major topics. That is, one is designing of the anti-sexual harassment policy, and another one would be the complaints and redressal mechanism. I've also prepared a PPT to just, let you know the crisp pointers on what grounds we have made, taken those things, and how standards will help you probably get through all of these things in your organizations. Just let me share my PPT. My PPT is visible.
Yes, ma'am. Yes, ma'am. It is visible.
All right. So when we talk about policy formation, implementation, and dissemination, the major problem that we see with organizations is that we have policies in place, we have everything on paper, but how far are we disseminating it? What efforts are we making as an organization, as an employer, to make sure that, okay, this is what we have written in a piece of paper, and this is what is exactly reaching the audience of the company. So for us, it's not the paper compliance that we are trying to do, but we are actually trying to reach the heart of reader. Because when we talk about policy, when we talk about drafting of the policy, I don't believe that people coming from the company secretarial background have been trained in such a manner, and they have been given that gift of drafting and communicating in a certain language to the stakeholders. So probably this is the area where we can be the torchbearers for the society, for the organizations, where we can show that, yes, this is what we are trying to write in the policy, and this is what we are trying to showcase in the policy, right? And for me, policy is talking about the culture of the organization. It's not merely a document that is there, kept with the board of directors or kept in your organization. Obviously, these days the practice is such that you are having that as a piece of paper, you are taking signatures of people at the end that we have read and understood each and every part of the policy. But how far does it stand true, right? So that's the questionable thing. So let us make our policy readable. Let us make our policy in such a simple language, which is not that legal. It's easy to understand for the people to know that, okay, this is something is made for our benefit. So there are certain rights for us. There are certain responsibilities that as employees or stakeholders we are supposed to follow. All of these things will be taken care in your policy. Talking specific about the standards, again, the governance and compliance standards on PoSH have given the outline of how your policy should ideally look like. So while drafting your policy, you can very well take the inspiration from these standards, try to include each and every point that is required. I'll come to that in the next slide. However, at the first, while you draft your PoSH policy, there has to be something that is known as the tone from the top, because as I said that this is a paper that is linked to your culture of the organization. Every organization has different values, different mission, different visions, right? So definitely our policy cannot be copy pasted. So if we pick up multiple organizations from the internet, more or less you're going to find the same policy drafting, because it's a copy paste of certain things that we do, right? Because it's a compliance tick box activity for us. But let us think beyond that. Let us take valuable inputs from our board members, from our senior management, from multiple HODs and multiple team members while we sit on this activity of drafting the PoSH policy. Because these people are experienced, they know about the culture of the company, they know how to deal with people, what is the perspective of leader. Everything has to count when you are designing a policy. Right? So this is something that should come, and your policy should always be designed in a real-time basis. Therefore, it should have its relevance with whatever is going on in the current times. So that relevance shouldn't be missed. When we design the policy, there are certain general rules. This page would look very cluttered to you. I'll just make sure that you are just getting to know the pointers, right? So whenever we are designing a policy, first of all, the policy has to be designed, formulated by every organization having 10 or more people. Okay, this is something that we have come out of our standards. Every organization having 10 or more people in their organization, they should have the PoSH policy to regulate the entire mechanism, right? Now, irrespective that you are working in a small setup or a large setup, immediately, if you have the number of people crossed, please design your PoSH policy, please create your PoSH policy. Your policy should be very comprehensive in terms of expressing, promoting that you are safe at our workplace. Okay, this is the inclusive workplace, this is a respectful workplace, and we as employers are taking that step for you, that you will be made sure that you are safe with us. So this is something that a policy should communicate. The policy should also tell and promote the zero tolerance against sexual harassment, because obviously this is made to let people know that we are not tolerating this act in any form, right? So this point has to be made very clear. Apart from this, the policy can be made gender neutral, as we have stated in our standard and compliance, governance standard and compliance on PoSH also, because at this moment, the current times we are into, the policy must extend not only to women, but every person who is associated to your organization in any capacity, right? So it could be men, it could be people from the third gender, or people coming from other communities, say LGBTQI plus A, right? So if we are trying to safeguard any person who's stepping in our organization, it becomes very important for us to, first of all, stick to the legal framework of the PoSH Act that is already given, and taking a step ahead, an extra mile, where we are replicating these kind of provisions, procedures for the people who are not women, okay, for the other genders at work, for example. So all of these things should be kept in mind while you are drafting this. Ultimately, through this policy, it should look like that you are nurturing mindsets of your stakeholders, because ultimately these are the people who are going to follow it. These are the ultimate readers. You are promoting gender neutrality. You are promoting that culture for us is the priority. So all of these things would matter when you are getting into drafting of the policy. Now, what should be the contents of the policy? This is the general principle I've spoken on, that, okay, these are certain things that I should keep in mind when I sit to design my policy. But obviously, there are the contents that we need to look at, that what should my policy contain? According to the standards and to the general practice that we are following, this is how your policy content should look like. The policy should have tone from the top. So tone from the top may come on a page, the first page of your policy, which we can give a heading as a preface or a forward, right? Obviously, in our compliance standards also, a preface. So the preface is given by the IS, right, from the ministry. So if that person is able to set the tone of the entire governance, that what is the objective, why we are making these compliance standards or PoSH governance standards, right? The same should be done with our policy. That what is the agenda, why we are trying to do so, and this has to directly come from heart, because every employer is indirectly communicating that, okay, these are our principles, this is our culture, and this is what we are trying to bring down to you. So that needs to be communicated via the tone from the top that they set. So that can be a part of your preface. Then the objective or purpose of the policy. Why you are setting up this? All right. क्या objective है हमारा? दूसरा, scope of the policy. Now, scope of the policy should inculcate what, up to what extent are you wanting this policy to extend to? It is only extending to your employees, or it is also going to your third parties, your vendors, your suppliers, or anybody else, right? So that scope needs to be defined very clearly, right? Because people, if they are reading the policy, they should know, okay, this is made for us and we are covered into this. So that scope definition is important, that when you define certain terminologies in the policy, like sexual harassment, workplace, aggrieved person, employer, employee, these are some basic definitions that form a part of your PoSH policy. So try to make it very relevant in terms of, giving a definition coming from PoSH Act, saying that section so and so defines this particular term. That is not going to make sense. We are defining certain things, and people are, equipped enough to go and read the act and understand that definition. But if you're giving something in the policy that has to be curated from your end, so therefore having lots and lots of examples to make it relevant and easy to understand would matter a lot. Giving scenarios, helping with illustrations that, okay, this is something what we are trying to communicate. Now, if we are talking about sexual harassment, then we should also talk about virtual sexual harassment, right? Because these days, it's not only having a physical connotation attached to it, but it may come to you in any form. So it can come to you digitally, it can come to you verbally, non-verbally, it can come to you psychologically. So these aspects need to be clarified in your policy. There are certain responsibilities of the employer that are identified by the act. Please mention that. Tomorrow, if somebody from the organization comes and tells you that I want to go and file FIR with the police, right? The employer shouldn't be saying no to it. Because if the employee or the stakeholder is unaware about this particular thing, that this is our right, this is our primary right to go and file FIR with the police, if we are not willing to go to the IC, or if we don't want that entire procedure to be conducted by IC, so our employer cannot say no to that. How would that this entire provision, how ye kaise pata chalega employees ko? Obviously this has to be stated somewhere. So policy is going to play that role, of bridging the gap between the employer and the stakeholder, where relevant provisions are communicated in a very, very simple language, right? Then there are certain expected behaviors that we try to identify and that we try to communicate to our employees that, okay, this is acceptable, this is not acceptable. So again, having that sort of an understanding in the policy, giving a reference of your clauses, policies in the code of conduct policy, trying to, talk about how your dress code should be, how your, what do I say? I mean, if you're using a virtual background, how that virtual background should be looking like. So an extra mile, if you go, probably you are going to provide an appropriate scenario for your people to understand that this is what we are looking for. Right? Timelines and redressal mechanism. Obviously, PoSH Act is meant to fast track your entire complaint resolution, right? Otherwise, you would have gone to the police, you would have filed the FIR and taken the normal route, which would have taken years. But PoSH Act is here to specifically tell you that, okay, we are here with a specific deadline, we are here with a specific timeline to follow. So those timelines are to be provided in your PoSH policy. Who can file a complaint and conditions attached? For example, now I have a myth that I am an aggrieved person and only I am supposed to file a complaint with the internal committee. there can be multiple grounds. What if I am, physically hurt due to the act of sexual harassment? What if I'm undergoing counseling sessions? What if I am in a rehab center? So cannot anybody else on my behalf come and file a complaint with the internal committee? So that has to be mentioned. Of course, they can. Any person in general who has knowledge of that entire incident may come and file a complaint with the internal committee or the appropriate authority with the consent of the aggrieved person. So that has to be specified. Then there are certain reliefs that are given to the victim and to the accused during the pendency of the inquiry, right? So those reliefs could be the transfer, it could be change in the reporting line, it could be giving giving extra leaves, something of that sort. So even that needs to be specified in your policy, that these are certain things that you can ask for, right? Then we have to talk about when monetary the compensation can be triggered. In general, PoSH law doesn't have any sort of monetary compensation. If there are conditions that are identified by the PoSH Act, and of course the clarity has been given by the governance standards on PoSH, that when, in what situations monetary compensation would attract. And this is the sole discretion of internal committee post considering all the documentation that's been showcased to them, that okay, now yes, this is something that requires our attention, and this is where the monetary compensation can be triggered. But again, looking at both the sides of the coin, you will have to understand the position of the victim and position of the aggrieved. So that has to be mentioned in the policy. Disciplinary actions and recommendations. Okay, I have done something wrong, but if I'm not fearful of the disciplinary actions taken against me, I'll keep on continuing with that sort of a behavior, right? So that has to be mentioned. Consequences of false and malicious complaints. If two people get in a mutually romantic relationship with each other, okay, and they break off after a certain while, their relationship goes for a toss, then one of the parties think, okay, now I need to take revenge. Now I want to, defame this person. Let me go and file a case of PoSH against that person. So there has to be something that talks about the consequences of having false and malicious complaints, right? So it's not that simple that act is woman centric and we are trying to protect women at work so women can do anything, right? They are empowered, but at the same time, with the help of standards, we are also trying to empower other genders at work so that equality in all senses maintained. Essence of confidentiality is something that we need to understand, because whatever we talk about sexual abuse in the organization specific to the investigation part, that has to remain confidential. It cannot go out, because the direct linkage of confidentiality breach is with the mental health of the person. Because we usually hear that term called guilty until proven guilty, innocent until proven guilty, correct? So जब तक हमें गिल्टी प्रूव नहीं किया गया तब तक हम innocent है. So there are two parties involved in this. One is the victim, another one is the accused. Now both of them are already in a trauma. They are battling with something. Moreover, if you breach confidentiality, that gives rise to gossips. That gives rise to such an environment where people are not comfortable to work. So there is where the essence of confidentiality lies when it comes to inquiry procedures. So that shouldn't be breached in any form. And again, the consequences of the same must be communicated in your policy, right? That nobody takes these things for granted. Next is importance of training and sensitization programs. That is very well covered by Kavita madam, that how important is training and sensitization programs for an organization. Now, how frequently you should be doing it. Act says that it has to be done in regular intervals, but again, standards have tried to identify a procedure where it can be done in some sort of intervals that are defined under the standards, right? Monitoring mechanism. Now, once your policy, your PoSH implementation, everything is in place, how frequently should you be revisiting your policy, making it relevant to the current times, just changing certain terminologies into your policy, kitne frequently aap is cheez ko karenge? So again, the standards have given that, you'll have to do that annually. It's suggested that you do it annually. So this gives us a clear mindset that, okay, now every year I'm supposed to revisit my policy, correct? That gives me the relevance with the current times. Next is disciplinary actions, consequences. I think all of this we have covered. Sorry, this is the repetition of the slide. Now coming on to the very important portion, that is implementation of the policy. Now policy is drafted, it is designed, it is curated, considering everything that is there in the organization. Now the major part comes is of the implementation. How should we implement it? Okay, and only says about policy formation, implementation, and dissemination. Okay, these are the three terminologies that are used. But how to do it? So our standards make it very, very clear that implementation has to be done in a certain manner. It has to be adopted by the board in the board meeting. All right. So every policy that is adopted by the board in the board meeting should be passed via board resolution. All of these mechanisms, all of these procedures need to fall in place, because ultimately you can only show that my PoSH program is implemented if I have proper paperwork in place. And how do we do that paperwork? Because we are not aware of the procedure, right? We are given that handholding with the help of these governance and compliance standards that, okay, this is how you're supposed to maintain your papers. This is how you're supposed to make compliance in spirit, right? So that's the entire objective that we are trying to communicate here. Now, dissemination of the policy, this is the major portion where maximum of the organizations fail. All right. We draft the policy and we have taken the board approval, everything we have done. All right. But when it comes to dissemination, the only thing that we do as organization is that we give a 20-pager copy to our employees and we ask them to sign it off and say that we have read and understood everything that's a part of my PoSH policy. Right. So that is what we are trying to do. If we are trying to do that, we are not reaching the audience, correct? So now for that matter, you have multiple things available with you. You can put your policy on the website. You can communicate bits and pieces of those policies in your brochures, in your newsletters. You can communicate via intranet. Okay. You can display certain thoughts around that entire policy. Ultimately, kya chahiye? Communication chahiye na? Now, 15-20 pager, a person is not going to read. We know that there are certain important pointers from these 50-20 pages. Let's pick those pointers out and let's try to communicate them in bits and pieces. Over information करेंगे तो बहुत सारी चीजें आ जाएंगी. Bits and pieces में हम information देंगे, rather it's going to create a good impact, right? थोड़े थोड़े समय में bits and pieces में आप information देते हैं, visual posters के जरिए देते हैं, regular meetings के जरिए देते हैं, अगर आपके टीम मीटिंग्स होते हैं उसके जरिए आप देते हैं, नोटिस बोर्ड्स पे लगा देते हैं. Regular communication is something that we are looking at. It doesn't require a specific training session that no, today I'm going to talk on policy. In regular course of communication, you can try to implement these methods and make sure that how well the policy can be disseminated. Now, coming on to my next portion, that is redressal mechanism. Redressal mechanism is very, very typical to understand when it comes to the legal formalities of it. But when the redressal mechanism under the Act talks about two methodologies, one is formal inquiry, another one is conciliation. Now, formal inquiry and conciliation, both of them require a hardcore paperwork, all right, documentation, because ultimately everything has to be presented. God forbid if there is a case against you in the court of law, how are you going to prove yourself that, okay, this is how we conducted an inquiry, this is how we were trying to, follow the principle of natural justice, and this is how we were exercising our powers as internal committee members, correct? So there is a timeline to be followed of filing a complaint. Who should file a complaint? I've already spoken about it. What should a valid complaint contain? Now, we have tried to given a format of filing a complaint under PoSH Act, or under the governance standards, where you can actually mention that, okay, this is the name of the party, this is the name and details of the accused person, this is the relationship between two of us, these are certain witnesses or evidences that we are able to collect, this is the rapport that we were trying to have in our organization, whether he was my direct manager or wasn't, date, time, place, description, everything is supposed to be mentioned. Right. In addition to that, we have, escalation of the complaint, because sometimes it may happen that the IC members are not acknowledging your complaints. They are not answering to your complaints. And how do I raise my concern? So even those things are provided in the governance standards. Exploring the option of conciliation, because conciliation is something that has to be done mutually. All right. So IC should never be pressurizing people to go for conciliation. राइट अगर अग्रीड पर्सन की इच्छा है और उन्हें लगता है कि कंसिलिएशन से मैटर सॉल्व हो सकता है, ओनली देन ऑन द रिक्वेस्ट of the aggrieved person, a conciliation can be done. Inquiry mechanism, I've already spoken about. Importance of documentation is something that I would like to focus on here. One second. Yeah. Documentation, why we are doing that documentation? Documentation is basically to keep track of the incidences that have happened, demonstration of seriousness of the matter, and to avoid troubles in the court. Ultimately, management is going to pay price for whatever wrong we have done while conducting the inquiry, right? Howsoever we follow the principle of natural justice, we have been given the powers of civil court, everything we follow. Okay, but if we are not maintaining that fairness, transparency, and proper documentation, the entire inquiry goes for a toss, right? And that is where the importance of documentation comes in picture, where we have to prepare certain documents that are pre-inquiry, during the inquiry, and post-inquiry. ऐसा नहीं होगा कि सिर्फ हमने ड्यूरिंग द इंक्वायरी कुछ चीजों को मैनेज कर लिया एंड वी आर गुड टू गो. नो, we have to manage the documentation, right? We have to do it correctly. Copy of the complaint received, proofs उसके साथ क्या आए हैं, witnesses की क्या list रहे होंगे, copy of acknowledgement of those things, notice that is issued by the IC to the respondent to answer that आपका क्या take है इसके ऊपर, उनके reply की copy, proofs, all of these things will form a part of your pre-inquiry. During the inquiry, you will have certain statements filed by multiple people, including complainant, respondent, and the witnesses. आपको उनके सारे statements पर signatures लेने हैं. If it is a virtual meeting, then the transcripts should be signed by the presiding officer. Now, these are certain standards that are provided in the governance and PoSH compliance standards by PoSH by ICSI. Now, Act is very silent on this. Act doesn't say that what all documentation you are supposed to do, what all things you are supposed to keep in mind while documenting all of these things. So standards यहाँ पर बहुत बड़ा रोल प्ले करते हैं कि आप इसको किस तरह से पुख्ता कर सकते हैं, right? You need to make things concrete. And we are coming from that company secretarial background. We totally understand कि concrete paperwork होना कितना जरूरी है, right? So confidentiality agreement is again something that we should be signing at the start of inquiry. Every person who is involved in the inquiry mechanism should be signing that, correct? So if the accused, the victim, the IC, the witnesses, everybody will say that we are not going to let go a word out of this particular thing. Now, there can be, post-inquiry documentation list also, where you are asking for, when you are giving the detailed inquiry report to all the members of the IC, to the respective parties, आप उनसे उनकी representations भी मांगते हैं. आप मैनेजमेंट को अगर आपने बीच में किसी तरह का हेल्प किया है टू मेक देम अंडरस्टैंड दिस एंटायर केस, उसके अगर आपके पास कोई पेपर वर्क है तो ईमेल्स है, वो सब आप समझ के रखते हैं. आपके मिनट्स जो हर मीटिंग के होते हैं आप उसको संभाल के रखते हैं. Everything needs to be preserved. And in addition to that, if you feel that none of your parties are answering to the notices given or to to the statements if you have sent for signature or anything, अगर आपने registered post या speed post किया है, उसके receipts को भी आपको संभाल कर रखना है, right? So यहाँ तक का पेपर वर्क हमारा रेडी होना चाहिए so that we are all set. So this is not a cakewalk. This is something that standards will help you to understand, because as I said earlier also that this is something we are talking on the procedural front, we are talking on the modus operandi. So I'm sure that standards is going to give you a very good insight on how PoSH can be practically implemented in your organizations. And I'm also very sure that as the torch bearers coming from the ICSI, we will definitely make sure that our organizations do follow all of these principles and follow entire procedure, and we'll be happy to go then. Yeah, thank you so much.
Thank you so much for this detailed and definitive session, ma'am. Now I would like to ask Kavita ma'am, CS Kavita Bhavsar ma'am, to continue the session with her presentation. Thank you so much, ma'am. Over to you.
Good afternoon. Am I audible?
Yes, ma'am. Ma'am, you are audible. Yes.
Yeah. So thanks to ICSI for taking up such a good topic. My today's topic deals with the internal committee and publication in annual report. So now, what is internal committee? Before I start, whenever a complaint is received, the complaint is made by aggrieved woman in case of PoSH, and in case of our ICSI standard, it will be made by aggrieved person. We have used, but in both the cases, IC will be same. So who can be the member of IC and who will form the IC? IC will be formed by the employer of the organization, and who can be the member of internal committee? As per the act and as per the standard, there can be minimum 4 persons. So the first person is called presiding officer. The presiding officer is always has to be a senior most woman employee of the company. And how do you find out senior most? Not only in the terms of age, but in the terms of experience, in terms of the power, in terms of the knowledge, a person. So presiding officer has always have to be a woman. Then there has to be 2 members from the organization. That member can be male or female. And the third person is a member from the NGO. Now, NGO person can be see the first presiding officer and the remaining 2 persons are from the organization. So the fourth person, that is a member of NGO, is an outsider person. But the most important thing which organization has to keep in mind while forming the IC is that in any case there has to be its biased decision. IC gets biased in decision, then the outsider person will be able to say his or her say. It is better to form an IC with the odd number of persons, so that in case of sometimes it happens when all the members are not having the same opinion about the judgment. So if it is an even number, there will be tie. So it is better to have an odd number of the person. There is no limitation for the higher number of person, but minimum number of person is mandatory, that is 4. Now the second step in the IC is what is the role of IC? The most important role of IC is to look into the complaint received by them from the complainant. There is a time frame provided for each and everything in the PoSH Act and ICSI guidelines. So the first thing is that any person from the PoSH committee, IC committee can be a person to whom a complainant can write a complaint. In some case, if IC is aware of some wrong being done, but IC on its own cannot take a complaint, IC may guide the person who is undergoing harassment. So the complaint has to be filed by the complainant. There is a time frame within which a complainant has to make a complaint to IC members. This time frame is 90 days, though it is written 3 months. Generally, we take this 90 days. Now, from when does the IC starts counting 90 days? That is the date of the incident of the sexual harassment which a complaint is referring. So there are times when the complainant is not in a mental condition or a physical condition to make his or her complaint to IC in 90 days. In that case, there is a power to IC to extend to take the complaint on within another 90 days. But then in that case, IC has to justify why IC has given an extended time. Second thing, when IC starts inquiry, IC has to first receive a complaint in writing. If IC has not received a complaint in writing, or the complainant has just informed verbally to IC should help complainant to write a complaint. How to write a complaint? So what should be the complaint? IC should not say exactly you write this, but IC can always guide, and IC should always guide that these are the basic things of a complaint, like the name of the complainant, the person against whom the complaint is made, what is the time or what is the date on which the incident occurred, or during for how many months or period this thing is going on, and the person has to give 6 copies to the IC. Upon receiving of the complaint, the role of IC starts. IC member has to call a meeting, give a copy of the complaint to respondent. There's a time frame for IC also. Once the complaint is received by IC in writing, the time for IC also starts running. They also have got a 90 days. So there is not much of the time for IC member, because IC member is not exclusively IC member. They are also having a different role in the organization. So calling the meeting of IC members and going for the inquiry, going for the conciliation, it takes a lot of time. Practically, we have seen once you got a notice, in one of the cases, complainant was not willing to come on the time when you are asking her to be present. She will say, today I am not well, in the way she was dragging. She almost dragged 30 days. So IC's 90 days reduced to 60 days. So IC has to be very clear about their role, that their role starts within from the date of receipt of the complaint, and their role also ends within 90 days. And in between, you have to call complainant, you have to call respondent, you have to call the witness, you have to take their statement, you have to make everything is in writing. In one of the inquiry I held, the person, the complainant was not willing to sign her statement. That was a very strange thing. And then the most important thing, IC has to be neutral and fearless. Why I'm saying fearless? Because if a complainant or respondent, if any one of them is very close to the management, the pressure may come from the management. Okay, ये इसने ऐसा किया तो कोई बात नहीं, आप ऐसे करके छोड़ दो. And going against management is one of the difficult tasks in a job. And this is, I'm saying all from my experiences. Whenever I've handled a situation, then you will get a pressure from the political parties. You might have a pressure from the Commission for Women. So each and everybody tries to put their point. So IC has to be unbiased. If just a lady has made a complaint, it does not mean the person against whom the complaint is made has done the fault. No. And it doesn't mean the lady is making the complaint, so she is of not a good character. IC has to be very, very gentle in handling the cases. It's just many times people find that lady has made, oh, she is like this, she wanted to stop her transfer, she has made. Maybe you are knowing right, you are knowing everything, but when you are sitting on the position of giving your judgment, you have to be very, very careful. You have to make sure neither complainant nor respondent has got any deficiency from your behavior. Second thing, when IC starts inquiry, IC has to make very sure each and every document has to be in writing. Verbal does not help you. One of the cases which started in my organization in the year 2016, we had captured everything, and the case went on till the last year, 2023. And each and every document, whatever we have got signed from all the complainant, respondent, witnesses, was presented before the court. And as a result, we were saved. Second thing, I'm very happy to say that what the ICSI guidelines have come now, we are following these guidelines without any rule from 2015. IC is conducting every quarter a meeting with a notice in writing. This notice in writing to IC has saved us. In one of the inquiries, when a lady has gone to West Bengal Commission for Women, the West Bengal Commission for Women has asked the company that you have not formed the IC, you don't have internal committee. So one of my notices, the beginning notices, 2-3 notices for each, as I said, we used to have and we still have every quarter a meeting of IC members where we give notice in writing, we give agenda in writing, we send through email. We, after the conclusion of the meeting, we note down how many complaints, whether any complaint was received from the last meeting of IC to this meeting, whether any complaint has been received. And in each meeting, we do sensitization. Each meeting, we write down that in this particular location, sensitization program was conducted by IC. So IC's role is not only for the inquiry, IC's role is much wider, spreading awareness, sending sensitization among them. And the second thing, when we go for sensitization, we make it very sure it is not only the woman employee who attends the IC sensitization. We give equal importance to the male colleague because they should know what are their actions which will be tantamount to sexual harassment and what are their behavior which is not acceptable by a woman. And IC has got a time frame. So as I said, within 90 days, IC has to complete their inquiry report. One thing is that before the inquiry starts, IC can ask the complainant that he or she can go for conciliation. If the person is willing to go for conciliation, then only the IC can ask for the conciliation, but no monetary benefit can be awarded by IC in conciliation. But if the complainant is of the opinion that he or she doesn't want to go for conciliation, then IC has to start its formal inquiry and the process goes on. And before 90 days ends, when both the complainant and aggrieved person or the respondent, when both of them are employee, then finding has to be done by IC. This finding is to be given to both the complainant and respondent, and they have to be given a time of say around 5 to 10 days to give their comments on that. After again taking their comments, IC has to give the final report. Now the IC final report is to be signed by all the IC members. It is not that the only presiding officer, whatever presiding officer will say, it will be working. No. And why the signature is required? Because tomorrow nobody can say that I was not agreeing to these comments or I was not agreeing to this. Tomorrow, there might be difference of opinion among IC member. So each and every IC member should sign the final report. A copy of the final report is to be given to the employer of the company, and the copy is also to be given to respondent and complainant. Make sure you are giving to them by a registered post or speed post so that you have got a documentary evidence. Secondary, if you have got an email ID of both the parties, you scan and send to them also with an acknowledgement. So the role of IC as far as the inquiry is conducted is over here. But whatever recommendation IC is giving, it is a duty of employer to complete those recommendations within 60 days. See, PoSH Act is a very small act if you go by the section in this, but it has defined very clearly the time within which everyone is supposed to work. So employer is supposed to act within 60 days on the recommendation of the IC. Now IC has got some power. One of the power is that in case IC finds that the complainant is not comfortable, they can give 3 months leave to complainant. This leave will be in addition to whatever leave the organization is providing, or at the request of the complainant, they can ask the respondent to be transferred to another. And these are not the right of, I can say, complainant. It depends on the IC. If the IC finds it is okay, then only IC will be giving their judgment. Yes, the person is not comfortable, or she can, the person complainant should not, the reporting officer should not be the respondent for the complainant, because otherwise there will be bias. So the person who has made a complaint cannot work under the respondent. So the IC should keep this in the writing, and as the IC's recommendation are binding to the employer is also duty bound to follow, and they are supposed to intimate to the IC that based on your recommendation, we have taken XYZ step. Second thing, IC has to give their report. They are supposed to give an annual report as per the PoSH Act, as per the Companies Act, as per SEBI LODR. So what is the time frame for which IC is to give its annual report? As per the PoSH Act, during a calendar year, the number of complaints IC has received, number of complaints IC has disposed of, number of sensitization programs taken up, number of complaints pending. So that is a calendar year. At the end of a calendar, so from 1st January 2024 till 31st December 2024, say I am a chairperson, presiding officer of IC Western Region. So IC Western Region will give a report to the employer on 1st January 2025, maybe within 5-10 days, that during the calendar year 1st January 2024 till 31st December 25, IC Western Region has received this many complaints. Out of this, how many they have sold? If there is any pending, and these are the pending, and these are the number of sensitization. However, as per the Companies Act and SEBI LODR, we have to publish this information, this number of complaints in annual report of a company. But here, the year is different. Here, the year is not calendar year. Here, the year is financial year. So, when you are preparing annual report, you have to do the back calculation, taking 9 months from the calendar year and the 1 quarter from the financial year. And this is mandatory. There is a penalty for not forming IC. Now, who is supposed to form IC? In case of an organization where there are 10 or more employees, those organizations are mandatorily required to form a IC. There is no question that we don't have a lady employee, so we are not going to form. In case of government office, what type of the organization, private, public, whatever you say, they have to form an IC. There is another concept of local committee. Now, IC can look after only the complaints received by their particular organization, but there is a complaint of local committee. Who can make a complaint to local committee? Any person who is working where there is less than 10 employees, or a maid or house person who is working in a house where there is no committee, or the most important thing, in any organization where there is an IC, but the complaint is against the employer. The basic concept is that if the person against whom the complaint is made is above IC cannot work neutrally. So these are the 3 cases in which the complaint will not go to IC, but the complaint will go to local committee. Now, there is another question. When IC has given its judgment, there are two cases. One, either of the party will be unhappy. One will be going with the judgment of the IC, one will be not going with the judgment of the IC. So in terms of PoSH, section 18 provides appeal provision. So if the person is not happy with the or not agreeable with the judgment of IC, the person will make appeal as per under section 18. If a company has got a service rule, then the company senior will take, as per the committee will take the rules under rules appeal. Or if the company does not have a service rule, then under the Standing Orders Act 1946, the committee will be. Now, when IC is working, IC has to see two things very clearly. That whatever they are doing, it has to be under their power. It should not be that they are biased towards complainant or they are biased towards this or some person in IC is not coming. So IC has to keep themselves also updated with any amendment with the PoSH Act, and they have to take training also. Just because one training is not sufficient. You have to take each and every year how to write judgment, what are the things you should go through it, and how to handle the complaint. In one of the cases, we had received the complaint, but the person has made complaint and the respondent's parents went and requested the lady not to put the complaint. So before the IC started inquiry, the lady came, we had a meeting and everything, we called both the person. And that lady said, we are not interested in continuing. So we cannot ask them, no, once you have made the complaint, so you should continue. We are always here to help them. We are always here to guide. Second thing, we made it very mandatory in each and every location of our organization. Like the committee formation is, information about committee is pasted on the main information board. But most of the girls, when I inquired unofficially, are they aware about this circular where we have mentioned about the committee formation? They said no. So what we have done, each and every ladies toilet, when a person, we have pasted the committee of that particular zone in each and every ladies toilet. So all the name of the persons who are committee members of that particular zone, we have written there, their contact detail, their name, and who can make complaint to whom. That also we have written in a very small poster, but it is very effective. So as a result, each and every lady of our organization is aware about IC. Just formation of IC is not sufficient. You have to inform your colleagues also that this is, we are here to help you out. So I think that is what, if anybody wants to ask anything, I can comment on this.
Well, thank you so much, ma'am, for this detailed and descriptive.
I have a small presentation.
Sure, ma'am. Sure, ma'am.
The timestamp part is written. So it basically it talks about formation of committee. There are two types of committee, internal committee and local committee. And we have how many persons? So minimum 4 persons to constitute internal committee. Who can be the presiding officer? Presiding officer has always to be a woman. There can be another 2 employees. There can be men and female. And 1 person has to be from outside the organization. Subject always that at least half the member of the complaint committee should be women. Constitution of local committee is also there. There has to be concept of chairperson, 1 member, 2 members, and what are the redressal available to the complainant? Conciliation, inquiry, FIR, and T-box. This is something very uncommon. There is a Ministry of Women and Child Development Department which helps you to register your complaint on She-box. This is the inquiry process. There can be formal, informal, and formal. In case of formal, it has to be ICSI nodal officer. And this is a process of handling a sexual harassment complaint by IC. Complaint has to be made to IC within 3 months from the date of the incident. IC has to initiate inquiry and attempt settlement through conciliation at the request of the woman, and no monetary settlement should be basis for conciliation. Interim relief in the form of transfer leave, not allowing the respondent to review the agreed woman's performance, etc. and the inquiry report to be provided to the employer or district officer as the case may be within 10 days of the completion of inquiry, and the employer has to implement the recommendation within 60 days. This is a complaint process. Complaint committee checklist to review the written complaints and response to complaints, review the applicable policy, the act, rules, and other relevant laws, develop a plan, meet with the complainant, meet with the respondent, meet with the witnesses, record statements and have them dated and signed, review and adopt the plan as needed. Complaints committee checklist, proceed with further interviews as needed, analyze all the facts to develop reasoning, arrive at the finding, give recommendation, prepare the report, submit the file to the organization for implementation of the recommendation and for safekeeping. What the IC is not supposed to do? IC is supposed to do is create an enabling meeting environment, use body language that communicate complete attention to the parties, treat the complainant with respect, discard predetermined ideas, determine the harm. What IC is not supposed to do? IC is not supposed to get aggressive. This is some graphic description of the sexual harassment, interrupt, discuss the complaint in the presence of the complainant or the respondent. Timeline, submission of the complaint by the complainant within 3 months of the last incident. Notice to the respondent within 7 days of receiving the complaint by IC. This notice is as per PoSH. As per ICSI guidelines, it is 3 days. Reply with respondent. Respondent is supposed to reply to IC within 10 working days from the date of receipt of the complaint. Completion of inquiry within 90 days of the receipt of the complaint by IC. Submission of finding to both the employees during the course of inquiry, but before the submission of the report in case when both the parties, complainant and respondent, are employees of the company. Submission of report by IC or LC to the employer within the 10 days of the completion of inquiry. Employer is to implement the recommendation of IC in 60 days. The recommendation of IC is mandatory to be followed by employer. It is not voluntary. Appeal within 90 days of the recommendation. If the allegation is found to be true, then disciplinary action in accordance with the service rules to be taken by the employer. And if no service rules are applicable, the following actions can be taken: written apology, warning, reprimand, censure, withholding of promotion, withholding of pay rise or increment, termination from service, counseling session, or community service. If the allegation is malicious, then the same action will be taken against the company. Penalties for contravention. This is for employer. When an employer fails to constitute internal committee or fails to act on recommendation of IC within the stipulated timeline, fails to punish the complainant or malicious complainant, fails to include information as required under the Act in its annual report, or it contravenes or attempts to contravene or obeys contravention of other provision of the Act or rules, there is a monetary penalty of rupees 50,000 which will be paid on the employer for the first time. If the second time the same non-compliance is done, then twice the amount of the first will be done, or in ultimate case, the cancellation of the trade license can be done by the concerned department. Disclosure in terms of section 134 of the Act, we have to put in the board's report, and in terms of regulation 34.3, read with schedule 5 of CPLODR, we have to write number of complaints received during the financial year, number of complaints disposed of during the financial year, number of complaints pending as on the financial year. So with this, I conclude my today's discussion.
Thank you so much, ma'am, for this descriptive and detailed session. And now I would like to put some questions which we have received from the members of ICSI. So any one of the panelists may take the question and answer accordingly. So the first question is, what shall be done in case of the institution doesn't have a female employee with size of more than 50 employees? Shall a committee be constituted or not? If yes, who shall be members, as there are no female employees in the organization? Ma'am,
So should I respond this?
sure.
So the law is very clear. It talks about 10 or more employees. It doesn't say 10 or more female employees, right? Employee is a gender neutral term. So irrespective of the fact that you have female employees or not, if you are 10 or more employees, you are supposed to constitute IC, number one. Number two, it is a technical part, but if we look at otherwise also, You might not have female employees within your organization, but there could be people who are coming, the faculties or the sweeper or the vendor or the customer, they could be the female, right? So if they come to your work premises, it's your employer's responsibility to ensure their safety. And therefore, the law has mandated it that 10 or more employees. It didn't say that 10 or more female employees. So irrespective of the fact you are supposed, whether you are a female employee or not, you are supposed to constitute the PoSH policy.
Right, ma'am.
PoSH IC as well.
All right, ma'am. Thank you so much. And the next question is, if aggrieved party is a member of ICC committee itself, then what is the procedure which has to be followed?
I'll say a person has to resign from IC.
All right.
Because you cannot be a party to the IC and you expect the fair judgment. Whether it's a complainant or respondent, if any of the party is a member to IC, they have just to be the member of the company shall form a new IC to look into this. With both the person should not be there in IC.
And just to add it here, here the principles of natural justice comes in a picture, which says that no one can be the judge in its own case, right? So if there is a conflict of interest, either you are a victim or you are a respondent, and you are a part of the committee, the committee won't be fair, or the independent committee. And therefore, it is required, as Kavita said, that it is required to be reconstituted.
All right. Next question is, a suo motu apology amounts to acceptance of harassment? What if the lady takes it to file a criminal complaint? What will be the role of management to resolve the issue? So they're asking, if someone has suo motu given the apology, is it amounting to that confession that yes, we have done something wrong? That is the question they have asked.
Should I respond?
You can.
Divija, you want to say something, please?
Yeah. So here, when the person is coming and saying that suo motu, okay, we are accepting the thing that we have done. So either that is between the two parties. If the lady, for example, has filed a complaint and it has been written and it has gone to the internal committee. Now, internal committee will take it in full form in means of, making that lady know the remedies that are available to her. First would be the conciliation, another would be the formal inquiry mechanism, right? So these are the two things that will be told to that lady. If the lady opts that, okay, now I want to go for conciliation, hum sulah karna chahte hain, in that case, the written apology that the person is given will be accepted kyunki samne wala apni galti maan raha hai. One case. Now, if the other person is not accepting the mistake, of course, then the complaint will go to another level, that is formal inquiry. Now, the part is, aggrieved person can only choose for one mechanism at a time. All right. It cannot be conciliation kar liya, settle nahi ho raha hai, now I'll go for inquiry. So this cannot happen. An internal committee will keep in front of the lady ki ye do mechanisms aapke paas available and now it's your prerogative to choose what. Right? IC is not going to pressurize that lady to go for conciliation, because in such cases, again, I am re-emphasizing that mental trauma and mental health plays a very important role. So confronting that person, getting into that sort of a conversation may be difficult for the aggrieved woman or the aggrieved person for that matter. So it has to be dealt in a very legal format. Kavita, madam, if you would want to add on to this.
No, so I think here the question was that if somebody comes suo motu and offer the apology, right? What would be the consequence? I think you have very well captured here. The thing is, it is the aggrieved person who is supposed to lodge the complaint, right? Now, the aggrieved person has not lodged the complaint, and the respondent comes and says that, look, I have done this thing, I committed a mistake. Nothing is going to work. So first of all, as per the legal structure, it is required that the complaint has to be lodged, and then the next step will follow, right? And as she said, the conciliation is a mechanism, and very important, in the conciliation, both the parties have to agree for settlement. So in certain cases, it may so happen that the lady is ready for conciliation. However, the respondent says, no, I'm not okay with that. Let us have a fair inquiry. So in that case also, the conciliation will not come in picture. However, suo motu apology without having a complaint will have no consequence.
I would like to hear one line. See, the main crux of this PoSH Act is how a woman feels. It is not how a person thinks. So if she has been offended by his behavior, it is not the intent, it is the impact what a aggrieved person feels, that is more important. If the lady is happy with his apology or her apology, the matter ends there. But the person is not feeling comfortable with the apology, then the matter will start, as Divija said, the formal inquiry and everything will start. The most important thing is how a complainant feels, what is her mindset.
Ma'am, the other part of this question only, it says about the criminal complaint and the role of the management in such case. So if you can throw some light on this, the criminality of this particular setup.
Yeah.
There is no criminality. The person, the aggrieved person can file FIR. Here, neither can management support or stop that person. If he or she finds that I want to file a FIR, management cannot do anything. I mean, management cannot stop that person that no, please don't file a complaint. But there's a reversing. If the person comes to IC and asks that I want to file a complaint with the police, then it is IC is supposed to help that person how to file a complaint with the police. That is my take on this. The other members can throw the light.
No, yeah. So it is the prerogative of the complainant or the aggrieved person, what she wants, right? Or what the person wants. So if, as she said, if the person comes and says that it's a grave matter and I want to lodge a police complaint, then the IC will have to extend the support, because ultimately it's a sexual harassment case of an employee within the organization. And she has chosen another mechanism, going to the police, right? So the IC members the employer will have to extend the full support for lodging the police complaint.
All right.
Correct, because there are certain list of responsibilities that are identified by the act for the employer. And if that person is very well aware, so employer cannot step back and say कि हम आपको complaint file नहीं करने देंगे. So management का इसके अंदर say नहीं रहता है. The say has to be from the aggrieved person. And ऐसे भी आप अगर sexual harassment in general terms भी देखते हैं, so it is a criminal offense, right? So that was earlier covered by IPC, which is now covered by Bharatiya Nyaya Sanhita. So filing FIR in any ways is your primary right that is available to you. PoSH उसके बाद है.
All right, ma'am. The next question is, as per para 1.4 of standard, it is written that the presiding officer and members of the internal committee shall not occupy the office for a period of more than 3 years from the date of nomination. If the company review its constitution on PoSH committee and modify the committee, but presiding officer and external members remains unchanged and other members get changed, would be is in compliance of the said para, or is it not in the compliance with?
So the law says the IC constitution, I mean, the members will not reside in the position for more than and maximum 3 years. Now, if the same members are reappointed, for example, right, the presiding officer is reappointed or the external member is reappointed, it's up to the management of the organization, right? How they want to do that. So what you have asked is that 2 members are continuing and the rest of the members have been changed, right? It's a very well constituted body, according to me. Am I right, Divija, Kavita?
I have a different take,
Absolutely.
ma'am. Here, I feel all the members should be rotating maybe from one region, like what we are doing. We are having all over India. So we are, after every 3 years, we change. If supposing I was in IC Southern, now I'm with IC Western, or maybe somebody is in IC Eastern, he or she will be transferred to another IC. So that all the members are different.
No, so it depends, Kavita, because if you have
Depends
number
on how
of
many
women
members you
employees,
have.
senior women employees, then you can have this option available. There are organizations, small organizations where they
Try
don't
to
have
get
senior employees. So they have,
first woman employee in the higher post, second NGO person who is willing to join your IC. That is because for us it's a regular method. So we conduct it every quarter meeting, awareness. So the person has to give time in our case. It's not that just I assign meeting on paper करके हमने कर दिया.
so I'll just
I
put it in a way.
We thoroughly follow what standard is.
I'm also trying to come from a psychological perspective where, if for a period of 3 years, you have one set of IC that is taking care of certain things and the period expires, again, you're reconstituting that. There is also a comfort zone that is attached to those IC members, because किसी एक के साथ आप वो कंफर्ट महसूस कर पाते हैं, so that opening up chances or maybe voicing out concerns का chances जो रहता है थोड़ा सा बढ़ जाता है if the reconstitution happens. But as rightly said, उसको बार बार change भी किया जा सकता है. That is completely the option that is available to the management. But this I am thinking from a psychological front as an employee, that in case if the IC remains same over the years, is it giving me that comfort to come and voice my concern? That is what the thought has come to me. Just shared.
Yeah. So it's basically combination of both. The law doesn't say so that you cannot reconstitute. It just says that 3 years is the maximum period. So technically speaking, yes, after 3 years, you should change the constitution. But if the scenario is that you don't have employees in hand, you don't have senior women employees, what will you do? So rather than having a non-compliance in place, continue with the same person. But of course, you have to pass a board resolution, do the stuff which is required. Again, do the filing with the, notifying with the government body saying that, okay, this is the new committee.
All right, procedure has to be followed. Now, the next is in plantation sector, mostly women are employed in fields and factories. If any harassment happens at their residence outside office hours, will it fall under the harassment at workplace?
Harassment
No,
by
it will
whom?
not.
Employee of the organization, plantation company.
Yes, in plantation sector. Yes, ma'am.
So, say for example, a lady is working in tea garden.
Yes.
Now, after completing her work, she is going to her house, and on the way to her house, she has been harassed by one of her co-workers. Then it comes as a sexual harassment by this, because till she reaches her house. But if somebody else is doing, then it does not cover under this act, to my mind. Other members can throw some light.
So here is the definition of extended workplace comes in a picture, Now, the law says that if you have gone to some other place for the purpose of work or during the course of employment, then it will be extended workplace. Right? Here the case is that you have left your workplace and going to your house. Now, there could be two possible scenarios. The person who is the harasser is your co-worker. Then, of course, as per the court judgments, various court judgments, it will fall under the PoSH. But if it is a third party, it's a roadside case, something has happened, then it's a matter of criminal law. File the FIR under BNS.
All right. The next question is, in case of multiple branches, whether IC has to be constituted in all branches or centralized IC is sufficient. Similarly, whether training session to be conducted in all branches or like it is specific to the branches, or the central office is sufficient. So
according to the Act, it has to be constituted to each and every unit, branch, or any office that you have. Now, coming on to the main point where we talk about having 10 or more employees, जहां पर आप IC बना सकते हैं, because IC बनाने के लिए भी आपको number of sufficient people चाहिए होंगे, right? If you have 5 people, then you not be constituting that IC. So in every branch, location, or unit or office, if you have 10 or more people, then you should be having a separate internal committee in place. However, scenario 2, it might happen कि आपके पास सारे branches में senior most female employee ना हो, करेक्ट? ऐसा भी हो सकता है कि आपके पास लीगल बेंट ऑफ माइंड से थोड़ा सा समझने वाले सेंसिटिव लोग ना हो. सो देयर अगेन अ कॉम्बिनेशन कैन बी डन वेयर द प्रिसाइडिंग ऑफिसर कैन बी कॉमन फॉर ऑल द ब्रांचेस. अगेन दैट प्रोविजंस come from the act. All right. And there is no clause that talks about having, different external members. External members can again be common for multiple branches, multiple units, right? However, जो दूसरे 2 members होने चाहिए out of the 4 members, they can be the representations from the respective branches. Again, the logic is respective branch people would rather understand their language rather than understanding the language of the head office. करेक्ट? जो आपसे acquainted हैं, आप उनसे बात करना फिर से थोड़ा easy समझते हैं. Head office एक compliance perspective से committee बनाती है. So if you have that feasibility of having people in place, go for it, because it's a compliance requirement coming under PoSH. But if you don't have, then we will have to work on such permutation combinations again within the legal framework of the act. I'm happy अगर आप लोग add करेंगे तो.
No, I think
to this,
very captured.
I personally felt I was, when Southern Region Chennai, I was IC head. They will not utter anything other than Tamil. And I am non-Tamil person, so I had a very difficulty in understanding what they are saying.
Correct.
So I always used to ask my another IC member, kindly translate. So if the person is from the same region, it is very easy.
Yeah.
Had we all
Easy.
been outside, we would not have been in a position to conduct even inquiry also. Forget about understanding the complaint.
Absolutely.
But this is a very, very practical and difficult scenario for the large organizations where they have offices across India or globally. So forming so many committees, doing so many compliances is practically is not possible. So nowadays the concept of having zone level committees, so like South region, North region, West, East, that can be constituted. However, we have to see that in South region, if there are 10 offices, in each office, how many employees are there? So pick up one employees from each office, make a committee of at southern region, but do the entire filing at every level wherever it is required. So in this way, you are solving your practical difficulties. At the same time, you are ensuring the compliance.
All right. The next question is, are there any specific qualification and criteria for trainers, members, and the chairperson of the internal committee under the PoSH Act?
Exactly. It's not exactly. Your experience teaches you. But
Correct.
yes, basic knowledge, once you are appointed as a member of IC, you should have a knowledge of the Act. You should go through on your thing will help you out. And as an experienced teacher.
I just want to add something here. My experience of last 10 years in the field is that law says that, okay, external member should be from NGO or the person who has knowledge or committed cause and blah, blah. All NGOs do not have the expertise in PoSH. So, suppose you are doing CSR for, and that, from that NGO you have acquired a person. Now, tomorrow you have a case. You have to follow the process defined under the law. If you don't do that, then they are exposed to the litigation. So my perspective is when I work with my client, I say, you don't appoint me, fine, but appoint a person who knows the basic ingredients of the law, who knows that if there is an issue, how it should be, first of all, addressed, what are the documentation required, what is the areas of sensitivities, confidentiality, principles of natural justice. These all things are required to be taken care while, inquiring into the matter. So the person, according to me, has to be technically qualified, backed up with the desired experience, should be your external member.
All right, ma'am.
You have a take on the presiding officer part, because presiding officer qualification clearly says that it has to be the senior most female employee of the organization, right? Now that senior most female employee can be counted on the number of years of experience, or it can be counted on the designation part also. According to me, the reason simple here is that that lady would know the entire culture and people of the organization. So she, being the chairperson specifically, would spearhead the entire IC, and external member will be the driver who will be in a transparent manner probably take up कि इसको कैसे हमें चलाना है. And बाकी दो members के भी qualifications नहीं दिए, but they have clearly said that the person should be sensitive enough to understand this entire concept of PoSH. कल को ऐसे नहीं होना चाहिए that somebody who is gossiping around in the organization becomes a part of your PoSH committee. So while choosing those right members on board is again a task that employer should carry out very proficiently.
All right, ma'am.
It is a duty of employer to train the IC members also. Not only the sensitization about the IC, it is a duty of employer. So before forming a committee, the employer should decide that I am going to form a committee with this many persons. So let me first give training to all the persons who is going to be IC of my company. That is a good situation where the person, if someone gets some complaint, that he or she is not suddenly unprepared to how to handle the complaint.
All right, ma'am. The next question relates to the type of employees should be included in the number of 10 numbers for the requirement of IC. It says number of 10% includes only on direct payroll of the company, or even those on contract basis or retainer basis, or trainees should be included in that.
All are included in the number 10. It does not differentiate among the employees. Contractual, if you go into that, any type of employee is covered under this act.
All right, ma'am. So the next question is it mandatory to take board approval for change in ICC, ma'am? As Kavita ma'am already told, in the procedural aspect, you have to go with the board resolution, so that if you are renewing that. So it has been asked, already answered. The next is, what is the frequency of meetings to be conducted by the IC under the PoSH Act and under our standards? So initially, Kavita ma'am only told that it has to be done when initially when the person joins and the yearly also. But ma'am, please, if you can.
So it's about training or it's about meetings of IC members?
Frequency of meetings to be conducted. Yes.
IC meetings we are
Yes,
talking
yes,
about,
yes,
right?
yes.
So the law says that the IC meetings to be conducted, but again, it doesn't say. So I think in our standard, there is a clarification on that minimum 2 meetings are required to be conducted.
Yeah,
right?
yeah. We have done with 2 meetings. Yeah.
Yes, yes. So like I just tell you the practical, the market scenario. In most of the listed companies, it is kind of a quarterly meeting, IC meetings, which they conduct. However, it's not mandatory. It's like, comfort of IC and the management, how do they want it? But minimum 2 meetings in a year are required to be conducted in compliance with our standard, and that would be sufficient.
All right, ma'am. Next question is, a complaint lodged by a former employee can be considered under the PoSH Act, as the Act provides mechanisms to address sexual harassment at workplace. So former employee can be. Yeah.
Sorry. See, if the
Yes, ma'am.
act is done, if the lady, when then she can be.
Ma'am, your voice is not audible somehow, I think.
Bandwidth issue, I think. Okay, so here, former employee can do that, provided it is within the statutory timeline, okay, within 3 months. If it is the case, then it can be, considered.
All right, ma'am. The next is if there is no complaint of sexual harassment in any financial year, is there still requirement to hold the committee meetings?
Yes. Committee meetings have got nothing to do with the complaints. Committee meetings are required for many purposes, that to see whether the policy has been disseminated properly or not, whether the sessions are being conducted or not, whether actually there are scenarios where people are not coming up, whether there is a trust issues or not. So irrespective of the fact whether there is a case or not, no case, the meetings are required. And they should be very limited as well.
Yeah, and even PoSH Act has done that sort of amendment in 2016 when the earlier name of the committee was given as Internal Complaints Committee, which seemed like they are only here to handle complaints. So that word complaints was removed and the scope was widened for the internal committee members by giving them the name Internal Committee IC. So basically, they are here to take proactive measures, create that preventive environment for people so that they are not reaching that redressal stage, basically.
Right, this is the last question for the from we receive. What measures can an internal committee under the PoSH Act take to ensure unbiased investigation and maintain confidentiality while addressing complaints of workplace harassment? So it has.
I just wanted to say one thing. I forgot to say that time. We are a government organization, so we regularly get RTI requests. So any information pertaining to, if it has been asked in RTI, then also we are not supposed to give that information. And all IC members are supposed to keep the confidentiality among the case which they are holding. Like say, for example, if I am having my colleague who is not in our IC team and I'm discussing with her everything, so tomorrow that person will go and talk to some other person, so the confidentiality will not remain there. So this is very, very important. In no way the name of the respondent, complainant, or what are the steps taken by IC is to be disclosed to anyone. It's a clear cut, any hearing, any inquiry is a clear cut, information sharing among the complainant, respondent, IC members, and only the employer to whom the report is to be submitted. No other person other than those persons which I have mentioned should be aware of this. I think I've said that part clearly. So if anybody would like to add.
I think you asked the question that how the independence of
Yes, the
IC
unbiased. Yes, both of the
independence.
things are there. Yes, confidentiality as well as the unbiased.
Yeah, so see, to be unbiased, it is your own mindset and your ethical values that how can you be. But technically speaking, if any parties to the case, maybe the complainant or the respondent, if they are reporting manager kind of status, or there is any conflict of interest, you should be the first one and go say that, look, I won't be part of this investigation procedure, right? Or if in some cases, if there is no other member who can be part of the IC, because of the lack of employee count, in that case, one has to disclose it before the committee that, look, she's the reporting manager or whatever it is. Okay. So basically the fairness comes from the mindset. There is no written rule per se. When four people sit together and inquire into the matter, the fairness and the unbiased attitude comes automatically, number one. And number two is, it's all about the system in which you work. The moment you sit on the chair of IC or the presiding officer, you automatically becomes a very, very independent person. And in all eventualities, IC is a quasi-judicial body, an autonomous body. It works independently without any influence, and the external members' involvement gives that privilege to this body that they work without any influence. So I think.
Right, ma'am. Thank you so much. It was a very, as we come to the conclusion of this event, I would like to extend my heartfelt gratitude to our distinguished speakers, CS Kavita Bhavar and CS Kavita Sethi and CS Divija Dave, for their time to share their valuable insights and expertise with us. Your valuable insights have significantly enriched our understanding on ICSI governance and compliance standard on PoSH. I would also like to express my sincere appreciation to all the participants and attendees. Your engagement and enthusiasm are what truly make this webinar meaningful and successful. Thank you once again for your presence and support. Thank you so much, ma'am. Thank you. Thank you, everyone.
Thank you so much.
Thank you.